say I'm going to endeavour to finish in around an hour, and that will leave me half an hour for my reply. I may go a bit over half an hour, which I appreciate will take more time out of my reply. That's your call.
Okay, well, I'm sorry we've lost 4 minutes. Clocks are not quite the same as the ones we have on our... but anyway, there we are. Keep going.
My lords, can I just come back on some references on the client point that you've raised with me? You take up Supplementary Bundle 1, tab 13. It's the defendant's response to a request for further information. And if you look inside, go to page 268, which is a few pages into the RFI response, you see some questions asked about exactly this, who engaged Dechert, who's the clients. It asks you, in fact, sorry, at 267 responses start. But,
yes.
The important ones are 8 and 10 over the page on 268, and also same point at 12 and 13.
Okay, just give me a moment. Yes. And I picked up from somewhere that RAC Development was legally a separate entity, and that we can see from the fact it's an LLC that so, but I think the Investment and Development Office is simply an agency of the government of RAK. That's right.
Well, they're the two different retainers, the first with IDO and then...
No, I understand that. I was just pointing out that they're slightly different statuses.
Yes, yes. A different reference, but to address the exchange I was having with my Lord Justice Popplewell about the public prosecutor, could you go again in this bundle, page 130?
130.
130, Mr. Allen's 9th witness statement, paragraph 57(1).
Sorry, which page? 130.
130. That point is actually reflected in my learned friend's skeleton at footnote 7, page 106, when they're discussing in the context of how things work in criminal proceedings. They say it reflects the approach they've taken, which is to treat communications with their former clients and the RAC public prosecutor as non-confidential and therefore disclosable. So they obviously accept the public prosecutor as not their client. My lords, just two short points on authorities left. In the judgment, you'll see that the judge relies also on the Queen and Gibbons in support of his proposition that a third party can claim litigation privilege. That's at page 184 of the bundle, 207 of his judgment. We say that reliance on that dictum is entirely misplaced. There wasn't any issue in Gibbons of this sort. And it just seems that the statement that was being made by the court there was simply to say it doesn't matter if the person in whose favour privilege arises in a particular case might happen to be a party to the proceedings or might be a third party or as a witness. It's just making a general observation about the importance of privilege as a substantive right that will be protected where it arises in favour of all manner of persons. So, and he was tentative about his reliance on that, but we say that dictum is not support for the proposition. My lords, you know that we also rely, I'm not going to take it to you, but another first instance decision, which is contrary to the judge's decision, the Minera, Bumbus and Glencore case at tab 35 of the authorities bundle. The only thing I need to say about that is Mrs. Justice Mulder regards the Guinness-Peat in exactly the way that I explained it to you, that it's a case about dominant purpose and whose purpose matters for the purpose of that test. And that, we say, is the correct approach to that case. And the same point again in relation to Ahuja investments and victory gain. We've got the first instance decision at tab 46 of the authorities bundle and the Court of Appeal at 47. Just need to look at, give you the reference, paragraph 19 of the Court of Appeals authority, Court of Appeals decision in that case, page 138, final volume of the, 1380, final volume of the authorities. The Court of Appeal approved the judge's summary of the principles and the gain that the analysis of Guinness-Peat that I've outlined about being about dominant purpose, they endorsed that. Well, you'll see, well, I'm not going to take you to them. We say the texts also support us on this part of the appeal, the authoritative text. And then there's also, although you may not regard it of much assistance, the fact that in foreign jurisdictions, for example in Australia, the Evidence Act there, which codifies litigation privilege, makes clear that in terms that litigation privilege can only arise in favour of a party. You've got that if you wish at tab 55 of the authorities bundle 1608. That's the law, my lords. Can I deal with what the judge then sets out about this sufficient interest test? And you may want to have the judgment in front of you for that. It's page 185 of the bundle. Paragraph 212 of the judgment. Now, my lords, my learned friends say that sufficient. We're wrong to say that this is a test. They say all the judge is doing here is describing a non-party client in whatever circumstances who creates or receives communications which otherwise meet the dominant purpose and the other applicable tests for litigation privilege. This is all that's doing. It's just describing that situation. I have to say we don't follow that because we think it's plain from what the judge is saying here that he is proposing a legal test, because he says what is necessary, if not sufficient in my view, and so on. And that is setting a test. Nevertheless, if what actually we think the respondents are trying to say is that it's not a test because all you need to consider is whether the non-party can satisfy the existing tests of litigation privilege. In other words, can the third party establish that there are actually proceedings on foot or they're reasonably contemplated, and can they establish dominant purpose? And if they can establish those two limbs, then they should be able to claim privilege. Now, if that is what they're saying, we say that constitutes a very significant expansion of the scope of litigation privilege. And I say it for this reason. That would extend litigation privilege to any communication prepared for the dominant purpose of actual or anticipated legal proceedings by anyone who was concerned or bothered enough to prepare such communications. That isn't the law. Litigation privilege doesn't cover all documents brought into existence for the purpose of actual or contemplated litigation, but only the ones that are concerned with the conduct of litigation, and I've taken you to authorities on that. And we say, my learned friends say, well, our objection is overdone because it will only be in unusual cases that the third party can claim, can satisfy a dominant purpose test. But my lords, that's not right. One can just think immediately of any case with a potential witness or expert. It seems to me that in virtually all cases, they would, on the basis of the defendant's articulation, be able to claim their own privilege in communications, because that potential witness or expert, they would have anticipated the litigation, or the litigation would be on foot, and they would have made their communications with the party for the dominant purpose of the litigation. So we say that alone demonstrates why the defendant's proposition, far from clarifying what has always been the case, it actually amounts to a huge extension. And the other problem with it is one can see immediately the kinds of...
And you say Schneider and Lee establishes that that's not the case.
I do, and I'll come to Schneider and Lee in one moment, my lord. We say it gives rise to huge difficulties, and one can just think about what might happen. The separate privilege, putative privilege of the witness or experts could potentially operate as a fetter on the party for whom the evidence is being or has been prepared, because it would mean that the party no longer had control over the communications because they'd need the consent of the witness or the expert if they, say, wanted to waive privilege in those communications. Another difficulty, my lords, one can envisage disagreement between these two putative privilege holders about what the dominant purpose of the communications was. Both parties might have a different dominant purpose in view, and how does the court resolve that situation? And to the extent that my learned friends will say, no, the principle wouldn't apply to all witnesses and experts, I would simply ask, well, why not? So we're back to the position that the sufficient interest criterion is obscure and its application is inherently uncertain. And just to deal briefly with my lord's point on Schneider and Lee, that's obviously the case where an expert witness was unable to rely on the privilege of the company that instructed them in subsequent proceedings. But if the defendants were correct about such privilege being available, then Mr. Schneider in that case, Dr. Lee in that case, could simply have claimed his own privilege on the basis that he would have satisfied both limbs. So that can't be the law, because that would have been the obvious solution in that case. So can I deal briefly with what we say would be I'm reminded that Lord Justice Hodgson in Schneider and Lee, in that case, page 119 of the authorities bundle, he expressly states that Mr. Lee had no privilege of his own. So in that case, Lord Justice Hodgson expressly addressed not only the issue of whether Mr. Lee could rely on the company's privilege, but also whether Mr. Lee had his own privilege, and he answered that in the negative. My lords, criminal cases and the disclosure regime applying there.
I'm sorry to hold you up.
Yes.
Does that mean that if an expert is somebody who often gives expert evidence, perhaps because it's quite a narrow area of expertise and he's an experienced expert witness, that he's amenable to what we used to call a subpoena duces tecum, to produce all the drafts of any reports he's given any of the previous cases on the subject? There's no privilege on those that he can assert.
He can't rely on his own privilege, no.
He can't rely on anybody else's privilege. He's got them.
Well, I think the position I think it's recognised that Schneider and Lee would be decided differently now, because there would be an obligation not to disclose on the basis of another party's privilege, and he in my lord's example, it wouldn't be open.
He would be bound to protect his former client's
Yes.
privilege.
Yes. Miles, we just want to say some words on what the sufficient interest test, its implications for criminal cases and the disclosure regime that applies there. And you'll see what we've said in our skeleton, that we say the sufficient interest test has concerning and potentially far-reaching implications for those cases. Because, of course, on the defendant's case, the victim of the crime should be entitled to claim litigation privilege in relation to their communications with third parties which satisfy the dominant purpose test. However, as my lords are aware, under the criminal disclosure regime, victims are treated as third parties for the purposes of disclosure, and their communications with for example, communications between witness and police will be disclosable if they satisfy the test for disclosure. And we've cited the joint protocol between police and CPS on third-party material in Authorities Bundle tab 61, page 1787, and the CPS disclosure manual. Now, my learned friend's response to this is to say, well, that this actually doesn't give rise to any sort of inconsistency, but all that we on this side of the court have identified here is a feature of the specific disclosure regime that applies in criminal proceedings. So they say, yes, we accept the prosecution has an obligation to disclose material in its possession, which undermines the prosecution's case or assists the defence case, the so-called unused material. And that might well include privileged material, but that doesn't tell you anything about whether, as a matter of legal analysis, privilege can be asserted over a document which has come into the prosecutor's possession and forms part of that material. So they say all our submissions on the criminal disclosure regime don't have any relevance to this question, which is before the court. But, my lord, that isn't a complete answer, because what they don't do, and nor did the judge do, is to seek to address or engage with the implications for criminal cases if their position were correct. And it's those implications which we say cut across that regime. In short, if a third party, including a victim, could claim litigation privilege, then the pool of material which might otherwise undermine the prosecution case and potentially might even exculpate the accused is likely to be reduced. Now, we know the particular disclosure obligations in the criminal regime only arise if the material comes into the possession of the prosecution. But if there was privilege available to a victim of a crime, that would very likely mean that that material will simply not become available to the prosecution in the first place. We've given an example in our skeleton, paragraph 83.2, page 68. For example, a report that the victim has obtained, which might be helpful to the accused, but the victim retains privilege over, and there wouldn't be any entitlement to require it. Effectively, the victim would be able to resist any request from the police on the basis of its claim to privilege. So we say there is a chilling effect that the availability of such privilege would likely have on the evidence gathering of the investigator and then on the disclosure that is subsequently made. Investigators would have an obligation, investigators do have an obligation to pursue all reasonable lines of inquiry, and that includes requesting third-party material. But it's hard to see how pursuing reasonable lines of inquiry that would enable any such privileged materials to find their way into the hands of the investigator or the police, because, as my learned friends have said, there's nothing to require a third party to provide such privileged material. So again, going back to my example, if the police had a suspicion that the victim had obtained a report of its own, which would undermine the prosecution's case, it simply wouldn't be able to obtain production of it. So we say the fact that a variety of third-party victim communications would never find their way into the pool of unused material cuts across the whole purpose of the criminal disclosure regime, which is there to promote a fair trial. Can I deal finally on my learned friends' points on why they say it would be unjust to limit litigation privilege to parties? And they give 5 examples, I think, in their skeleton at paragraph 83. If I can just take those in turn. It's on page 99 of the core bundle. In fact, the examples are all at the beginning over the page on 100. Sorry, 4 examples, not 5. So they say the first example where it will be unjust, it's not obvious why a victim of a crime preparing for an anticipated private prosecution should be treated differently from one preparing for a prosecution to be conducted by a public prosecutor. Well, as we say, that's a bad example because by assuming the role of prosecutor, the victim assumes disclosure obligations that will involve them necessarily needing to disclose materials that are subject to litigation privilege because they effectively take on the role of the public prosecutor. So there's no difference in treatment on our case. In the public prosecution context, the victim has no litigation privilege as it's not a party. And in the private prosecution context, the private prosecutor would need to disclose relevant materials, notwithstanding litigation privilege. 83.2, as the judge held, in the UAE, a victim of crime can make a claim for damages against the perpetrator within the criminal proceedings without the need to issue separate civil proceedings, but without becoming a party. Now, my lords, this might be an example of where the victim could be said to be a party or but in name for the purposes of that bolt-on damages claim. And I say only for those purposes, for this reason. It doesn't follow that because they are party in all but name for that part of the proceedings, that they should therefore be considered to be the real party for the whole criminal prosecution, and that they should therefore be able to claim litigation privilege in respect of the entirety of the criminal proceedings. So we say no injustice there. Sub 3 is about
I'm sorry to keep holding you up.
Yes.
I don't quite understand how you divide up the purposes, the civil purposes and the criminal purposes of the proceedings so as to apply them to a particular document.
Well, in my submission, it will be normally...
If there's no contemplation of a civil claim at all, then this point disappears against you. If, however, it is contemplated that there will be civil proceedings as an adjunct to criminal proceedings, then they are like civil proceedings, aren't they?
They are, but about the categories of documents over which the party could properly say they are for the dominant purpose of the proceedings couldn't extend to those communications which are about the bit of the proceedings which are not about the civil ones. So I think it would fail at the dominant purpose.
I understand how, in theory, that might arise, but if in practice the civil claim is dependent on proving the crime, I don't really see where there's room for a distinction in practice.
Anyway, it's not really a qualification you need to make, is it? I mean, if it was for all purposes, it would still be, you would say, distinguishable from the kind of case we have here.
Yes, yes.
My lord's not so sure about that.
Well, one of the criminal prosecutions was contemplated, was said to be contemplated, was a criminal prosecution in RAC against Mr. Sadeq.
Yes.
Well, my lords...
That was probably a gift horse. You should have looked in the mouth then.
I accept the situation of party or but in name, because I accept it in the insurer-insured context, is one where one may need to permit a situation where privilege can be claimed by another party. But on the facts of this, that my lords have before them in this case, and it's never been put on this way by my learned friends to say that they are party all but in name in all these proceedings. They've not said that. And my lords don't have the evidence to say that that is the case, that they are the parties all but in name.
Was there in fact a civil claim as part of the criminal proceedings against Mr. Sadeq?
We think that is right.
So you think there was?
Yes, I'm told that. Yes. We'll check, my lord, but we think there was. The third example is the insurer-insured, and I've dealt with that in the context. Yes. Just to clarify, my lord, the civil claim we think was made by Rakia, the investment authority, not by the client, by who were my learned friends, the Dechert's clients.
So when you did the civil claim, I see the civil. They were the loser who were entitled to benefit in accordance to the criminal, under the criminal proceedings. Yes, I see.
sub 3 is the insurer context, which I've dealt with. And then the fourth example, we'd say there's nothing surprising here. This is serious allegations may be made against X in litigation between B and C, which X cannot be or for whatever reason is not joined. X may well want to be advised in relation to the litigation or assist in relation to its conduct. We say there isn't anything surprising or unjust here because X can still seek legal advice, which will be protected by legal advice privilege. And to the extent that X assists with the conduct of litigation, his communications will presumably be subject to the litigation privilege of whichever of party B or C he is assisting. My lords, I'm going to, half an hour left, move on to legal advice privilege. My lords, as you all know, Mr. Sadeq's case is that there were aspects to the work that was carried out by the defendants which did not take place in a relevant legal context. And therefore, any communications for the dominant purpose of that non-legal investigatory work could not be withheld on grounds of legal advice privilege. The judge rejected that challenge and found that all of the defendant's work was undertaken in a relevant legal context, placing significant weight on the engagement letters. Now, below, Mr. Sadeq's submissions were centred on aspects of the defendant's investigatory work by which the defendants assisted the public prosecutor, and we said that demonstrated the defendants were performing a role akin to an investigator, a bit like a police officer, rather than a legal role. Now, we also seek to rely on the further evidence to show that Dechert's non-legal investigatory work was not confined to assistance of the public prosecutor, but that there was also other work and activities carried out by the defendant that did not take place in a relevant legal context. On the law, I think it's pretty much all common ground between us, and you've seen what we've both said in our skeletons about that legal advice protects communications which for the dominant purpose of seeking and giving of legal advice. That dominant purpose test was confirmed by the Court of Appeal in the Jet 2 case. We rely in particular on the observations of the House of Lords in 3 Rivers 6 about the relevant legal context and the way that the law envisages that there may be instances where the lawyer is not acting qua lawyer. To adopt the words of Lord Scott in 3 Rivers 6, the solicitor may be, for example, be acting as the client's man of business. Just so you have it, that reference for Lord Scott is at page 532 of the Bundle. There's also put a slightly different way by Lord Roger, part 539, about asking the lawyer to put on legal spectacles. So in essence, my lord, we say that there are clear instances here where Dechert were not acting as lawyers, they were acting as something akin to a man of business and were doing things that were not through lawyers' spectacles.
I'm sorry to keep holding you up, but can I just be clear about who we mean by Decherts here? The first defendant is what? Decherts UK or Decherts US? All right, come back to me on that. I'm perhaps more interested in who the retainer was with or who was instructed. The first letter of engagement has the address of the Dubai office, but I think, although it's not very easy to read, at the foot of the page has a reference to the Pennsylvania company, of which the Dubai office is registered as with the DIFC. So it looks as though it's an instruction of the global parent put in that phrase. And the judge certainly seems to have thought that who was being instructed was the global firm, in the sense of Dechert's US and all the emanations of the affiliates worldwide that one might put within that expression global firm. Do you accept that that's who was being instructed?
Yes, I'm just being reminded of it's pleaded in part in the defence, page 248. I think the point that my lord is on may be in the amendments in red on page 248.
Sorry, which bundle?
Sorry, supplementary bundle 1, tab 12.
Yes. But what I'm interested in really is whose advice, as it were, one's looking at the end of the exercise. Is it such advice as might be given by any of Dechert's, US Dechert's affiliates within the global law firm, so that, for example, what was contemplated as within the retainer would be advice, if necessary, on Georgian law given by a local office who was in a position to give advice as to Georgian law.
Yes. I'll see if we can get further information. It may be something that Ms. Reedy can help on as well.
Well, yes, I'll need to know what your case is,
I understand. I will, if necessary, in reply, or if those behind me are able to point to some other helpful passages. My lord, I was going to go to the engagement letters, because obviously the judgment, the judge placed put significant reliance on them. And they are in the supplementary bundle 2, tab 14. First one on page 281. Sorry, that's the second engagement. They're actually in the bundle in reverse order. The first one sees is the second.
Which you wanting to take the
let's
one
start
or
with
two?
the first. No, we're in bundle 2 anyway, but
No, I'm sorry. Which letter are you wanting to take?
Page 300. My lords, we see in the first paragraph that Dechert are asked to act as legal counsel to IDO in connection with an investigation into certain historical transactions carried out by subsidiary companies controlled by Rakia on the instruction of Dr. Hatem Assad, particularly in relation to activities and investments in Georgia and India, together with any other transactions which are identified by the task force appointed by the IDO. So it purports to be an instruction to do with investigation into past transactions, historical transactions directed by Dr. Massad. And then you have over the page, under scope of work, some rather curious wording about providing legal professional privilege. We submit those are the revealing, particularly in the light of some of the further evidence that I'll take you to in a moment about Mr. Gerard's trying to make arrangements so as to cover communications with the legal professional privilege. The second engagement letter is at page 281. And we say that it's very vague and broadly drafted, so it's difficult to see how anything useful can be taken from it. Obviously, the fact that Dechert says it's was previously providing legal services doesn't make that say that it was exclusively legal services.
Yeah, but on the point of who the client is,
Yes.
legal services to various entities within the government.
Yes.
So not confined to one entity, if it is indeed correctly called an entity, the idea.
Yes, I take that point, my lord.
And indeed, this one is addressed to the ruler and signed as a retainer by the ruler.
It is.
So I think it might be rather difficult to treat this as only involving RAC Defendant LLC as the client.
I accept that, my lord. At the moment, I'm just dealing with the point about.
I know you are, but while we're on them, I'm interested in who the client is. And I'm also interested in what you say about whether this was a letter of engagement which restricted previous scope of the retainer, as far as who the client was, or whether it could be said simply to supplement it by adding a specific new client.
Well, I will endeavour to come back on that, my lord, and I may need to in reply because I'll need to take some instructions.
Yes.
Now, we say these engagement letters are, to a large extent, on this point about the scope of legal advice, we say they're to a large extent self-serving, because it stands to reason that Dechert would describe their work in terms of providing legal services, precisely for the reason that people like to engage lawyers to try and ensure that, well, in this case, to ensure that their communications were protected by privilege. Now, I say that because when one comes to consider the further evidence, the lack of evidential value of these letters, not on necessarily on the client point that my lord is interested in, but on this point about what was the scope of the engagement, we say that the lack of value, it becomes apparent in the light of that evidence.
I see that page 281 in the final paragraph refers to a common interest agreement which is going to be prepared and which talks about reflecting and confirming the common interest privilege which exists in relation to all relevant RAK parties. Do we know any more about that than what we see there?
My lord, we don't, other than what I've shown you in the RFI, we don't have any information on that.
Okay, thank you.
Can I deal with how what we say the further evidence shows then? First of all, there's two aspects to the further evidence. There's the aspect of the further evidence which demonstrates Dechert's involvement in the hacking activity, and secondly, there's the aspects that shed light on the very broad scope of the investigation beyond legal issues, if I can put it that way. On the first point, there is the Gerard, what we've called the Gerard email in some of our submissions, which is in the further evidence bundle. Second volume, tab 7. Sorry. Yes, it is tab 7. Sorry, page 573.
Yes.
Well, I think email speaks for itself. It's obviously to Mr. Page, who produced the Page affidavit and is the source of all the RAC project reports. And we would say of significant concern, if I can put it that way, is what Mr. Gerard says there in the third paragraph about proposing that how they might go forward with the instruction of Mr. Page, and whether it would be appropriate that Dechert formally instruct him, as they have done with Mr. Del Rosso, who you'll be aware is another private investigator, so as to attempt to cover any work product under legal professional privilege. My lords, allied to that, we have...
Sorry, what do you say you get out of that?
Well, that...
Work product might be referring to the work product of Mr. Page, or it might be referring to the work product of Dechert's. If it's referring to the work product of Mr. Page, then this wouldn't be talking about legal advice privilege at all, would it? It would be talking about potentially clothing it with litigation privilege.
Well, I don't know whether it could be either that Mr. Gerard had in mind there, that it would be work product of Dechert where matters were being discussed, or falling under the banner of litigation privilege, either discussions within internally within Dechert, or discussions between Dechert and Mr. Page himself.
Your submission is that this is a recognition that without such a document, privilege wouldn't attach. Is that your point, essentially? That this is a recognition on Dechert's part that they need a separate instruction in order to gain privilege which wouldn't otherwise exist. Is that the point you're making?
Well,
I thought it was, but I may have misunderstood.
I think on the basis that there would be some concern that whatever Mr. Page was engaging in wouldn't have any basis for being subject to privilege unless it was somehow filtered through the lawyers. We'd say that was an inference there to be drawn. That if a recognition...
I might have been right about that as far as litigation privilege is concerned.
But an instruction, it wouldn't... There may have been a belief that, mistaken or not, that trying to... I'm not sure how full a detailed view Mr. Gerard was having of the application of privilege here, but he may have taken the view that if Mr. Page was instructed not through him as the lawyer, there was a risk that privilege might not attach because of the nature of the activities that were going on, but that if somehow it could be cloaked all within the lawyer's retainer, then there would be more prospect of being able to maintain privilege over it. I'm not sure whether in my submission, simply on the face of that email, and having regard to what else we now have about Mr. Gerard's evidence and his perjury at the Azima trial, this evidence is something which is not a thing that one would normally see a solicitor writing. We also have, my lords, the evidence in the Page affidavit. You've got that at the volume 1 of the further evidence bundle, tab 3. Really one needs to read the whole of this report, but for the present purposes I'm just referring to, this whole of this affidavit. But for these purposes, if you look at paragraph 23...
So, sorry, tell me where we're going.
Page 30, paragraph 23, which is about the mechanisms by which Mr. Gerard
Page 30.
Page 30 of Further Evidence, Volume 1.
Oh, sorry. I'm still in the... Yep. Oh. I'll get those in.
In fact, maybe it's just helpful to read paragraphs 18 to 23. It's about the whole protocol by which reports were received and how Mr. Gerard was concerned about receiving those at Dechert's offices, and he asked to have them sent to him at his home. So 18 to 23. So, my lords, we say that the evidence here illustrates that the work insofar as it involved these RAC project reports, the fruits of the hacking, that was not undertaken in a relevant legal context. Now, the other aspect in which I rely on the further evidence is about the scope of the investigation. And we say it does shed important light about its scope. The fact that the information which the ruler was gathering about Dr. Massad, a significant part of that didn't have anything to do with investigation into alleged frauds. And the parts of the investigation that we say are devoid of a relevant legal context are the ones that you'll find we refer to in our supplementary skeleton. I'll give you that reference, but let me just tell you what the parts of the investigation were. Firstly, the ruler's political dispute with his brothers, with whom Dr. Massad was considered to be siding. Secondly, a concern about Dr. Massad's competing business interests. Thirdly, a negative PR campaign by the ruler against Dr. Massad.
Just going a bit too fast for me.
Sorry.
Second was concern
about Dr. Massad's
competing business interests.
Yes.
The
third was a negative PR campaign by the ruler against Dr. Massad. Now, I'm going to just have, I'm afraid I've just to identify for you where the reference is in, but in our supplementary skeleton, which is in Further Evidence Bundle, second volume, tab 10, page 621, we've set out, it's the last bit of that supplementary skeleton, my lords, at page 630. We've given you the references to the various project reports to make those 3 points good, that the investigation incorporated aspects that weren't anything to do with an investigation into alleged frauds. And I'm sorry I don't have time to take you to all of them, but you have those references at paragraph 13.1, 13.2 and 13.3. We say, in the light of this further evidence, the court now has to consider the extent to which that casts at least some doubt on Mr. Allen's evidence about the nature of Dechert's work. Can I just briefly take you to what he says there? Supplementary Bundle 1. Tab 7. I'm going to page 124.
It's in 124.
124, and it's paragraph 38, that last paragraph on the page. My lords, we say it's in the light of the further evidence, it's now plain that Dechert's role, contrary to what Mr. Allen says here, was not simply to assist the clients in connection with suspected wrongdoing, because the investigation has many more aspects, as we've seen. And the other paragraph of Mr. Allen's statement, 47, paragraph 47, which is on page 127. At the very least, the further evidence puts a very different complexion on those statements. That this was some investigation merely into alleged wrongdoing, and there's no evidence for the proposition about the collateral damage and vendetta. In fact, the RAC project reports precisely support Mr. Sadeq's case on that, because they are not confined to alleged wrongdoing. They're confined to putting pressure on in these various other respects as well. And we say finally that the further evidence also lends support to the abnormal lawyer-client relationship in circumstances where the respondents have already accepted that Mr. Gerard encrypted, used encrypting, self-destructing and a screenshot proof platform with which to communicate with the ruler and Mr. Buchanan. You've got the reference to that at Mr. Chatterley's 9th witness statement, paragraph 18 and 19.3, supplementary bundle, tab 8, page 186. In the light of all that, my lords, we say that the judge's conclusion at 137 of his judgment, where he says, where lawyers are engaged to conduct an investigation, it is a reasonable and fair assumption that the engagement encompasses the investigatory work and related legal advice and assistance as part of a continuum of legal service. Well, we say that assumption cannot stand in the light of what has now been revealed about the nature of the investigation and its various non-legal aspects. My lords, we do continue to maintain our submission, as we did below, that Dechert's role as work as investigator, not merely as investigator, but as we said, stepping into the shoes of the public prosecutor, was extremely unconventional and not in a relevant legal context. And you have Mr. Chatterley's evidence for that, which is Chatterley 6, paragraphs 101 to 113, supplementary bundle, tab 2, pages 59.
So can you read that again? Chatterley 6.
Paras 101 to 113, supplementary bundle, tab 2, paras 59 to 66. I'm going to just take you to one more document on this point about Dechert's slightly curious role of quasi-public prosecutor. The new evidence also lends support to this. I'm afraid you have to take up the further evidence bundle again, volume 1. Now, the new evidence I am going to refer you to here is what is called a special report on Dr. Nassad's activities in Iran. It's page 198 of volume 1 of the further evidence bundle. I just explain where I'm going on this? Part of this report, and it's many pages long, you can't, it's not actually obvious where it ends, but it includes 10 numbered reports right at the back at pages 235 to 246, numbered 1 to 10, which you may have seen referred to elsewhere as the Assad-Rigby report. Now, these reports, which are attached now to this special report on KN's activities, those 10 reports, what's called the Assad-Rigby reports because of who the author and the metadata of the document refers them to, they were before the court below, but it was said that their origin was unclear and where they'd come from. And the relevance of the further evidence is that we now have, in this special report, and what precedes these attachments, is a description, and you see this on page 199, description as to this report being a highly sophisticated espionage operation that was launched against...
So which page are we on?
199.
Yep.
So it was said before that the reports we relied on below weren't really reliable. Where did they come from? This document now shows that, so far as Dechert's clients are concerned, they were considering internally that these were the product of a highly sophisticated espionage operation. They don't describe the findings as implausible or bogus. Rather, they describe it as a product of, I need to get this, yeah, at the bottom, refer to it as the product of some espionage actions. Yes, thank you. And if you could just turn the page to 201. Just the last paragraph, our sources have reported that as of February 2015, JA, that's Mr. Assad.
So sorry, it's my fault. Which page?
201.
201.
JA has already managed to infiltrate several RAC authorities and to develop sources that provide him with inside information. That's a reference to Mr. Assad, who's thought to be the author of these reports. So I just wanted to go to that to show you that although these reports I'm now going to show you were before the court below, they were not considered to be of any real value. But now we have evidence from Dechert's clients that they consider this all to be the subject of an espionage operation, and they don't cast any doubt on the truth of those. We say they have increased significance. And I just, if I may just briefly refer you to the passages which are relevant to this point.
Sorry, it's my fault, but I don't understand why this takes it outside the scope of legal work or legal context in the investigation. We're putting on one side iniquity. Lawyers are often instructed to investigate matters, and one thing that they may do is instruct private investigators to try and find out relevant information. If they do so iniquitously, that may invade the privilege, but we're not in that territory. What you're trying to say is because this is an exercise in trying to get information through espionage, it can't be within the scope of the legal context or legal investigation, which is what Decherts were instructed to perform.
I'm sorry, my
I'm
lord.
not sure
It's my fault. It's my fault.
I missed the point.
No, I just wanted to explain to you why we say I'm coming to the points in these attachments that go to the public prosecutor point. The only reason to take you to the earlier pages was to provide context for why we say these documents, which the judge obviously didn't think were worth considering, now have an added value because of what I've just shown you.
The espionage is not the espionage of the agents who are working through or reporting to Decherts.
Correct.
On the contrary.
On the contrary.
It's because of espionage that they have discovered what is going on.
Correct.
Yeah.
That's exactly it, my lord. I'm sorry, I've probably confused things. I could have
Well,
just
keep going because time is short.
Yes. I'm just going to take you to 243. And just the first 6 lines or so about asking Dechert law firm to run the prosecution. And then if you could also turn the page, the following page to 244, the second paragraph, RAC Palace representatives. But as we say, that's all evidence of again, as we said, not Dechert being merely assisting the prosecutor, but actually stepping into the shoes of and performing.
Would
That sounds pretty legal to me.
Yes, was that exactly?
Well,
We've all been in cases where the English lawyers have had to go and hold the hands of incompetent local lawyers.
but this isn't a local lawyer, Mother. This is the public prosecutor.
Well, same difference.
Well, isn't that stepping into the role of the effectively my point is that Dechert, Mr. Jarrod here, is performing the role of police officer and then CPS prosecutor. He's not performing the role of lawyers there to assist his clients. He's taken on a different role. Well, I think that's probably as far as I can take that point. 2 more minutes. Can I just deal with one clarification about the redaction that my Lord or Justice Mayles asked about the Mitchell note. You'll remember there was a very small redaction on that. That's page 402 of the supplementary bundle, tab 31. That redaction, we've checked, it is a redaction and it's been retracted on the grounds of legal advice privilege and litigation privilege, and the categories of litigation privilege relied on from the table, from Mr. Allen's table, the category 3, that's the criminal proceedings involving Mr. Sadeq.
Well, sorry, I think it was me who asked the question. It was so small, I wasn't sure it was a real redaction.
It is a redaction.
Yeah, well, that's all we need to know.
Okay. My Lords, I'm just going to say this on the Loudon Marshall application, and then I will conclude my submissions. I'm not going to make, obviously, any submissions on the law in view of the opinion that my Lord expressed in his ruling. It's obviously a matter of the court's discretion, and I hope I've dealt adequately in my submissions about the relevance and importance of the further evidence. And the arguability threshold that my Lord referred to in that preliminary ruling, we say, is very comfortably exceeded, both for the documents that are exhibited to the later witness statement of Mr. Chatterley, but also which doesn't present problems of delay because they weren't available to give to the judge anyway before he handed judgments, but also in relation to the earlier T18 documents. Can I just, though, conclude with one more point? I rely on everything I have set out in my skeleton argument for the Loudon Marshall application as to why the discretion should be exercised by the court to permit the evidence, and the points that I made before my Lord on that occasion, that really, if there was a default here by on our part, then in my respectful submission, it wasn't one of such seriousness that my Lord indicated in the ruling, and I relied on the fact that the documents were received on a rolling basis. There was always going to be an appeal, that was always known, and the parties didn't know that had any idea that judgment would be delayed in the way it was. Can I make, though, this final point as well? And I hope it's one that you'll understand now that I've been through all the grounds of the appeal. And that is, it is obviously our position on this appeal. The judge erred in his application of the law and the assessment of the evidence in very many respects. We would have had to have assumed, in order to provide the judge with that further material after the hearing had concluded, that would have had to be on the assumption that the judge would get the law and the assessment of the evidence wrong, and that he would do so in all the various ways that he did. And in my submission, to the extent there was a default, we would suggest it's not as serious having regard to that fact. It was reasonable for Mr. Sadeq to proceed in such a way that the judge would, as I put it, get the law right and apply it in the ways that I said he should, and that our default needs to be seen in that context. And unless I can assist further.
No, thank you very much indeed. Yes, Mr. Eden.
My lord, did it transcribe it? No.
Thank you.
I'll pass straight on. My lord, subject to your views, I was proposing to address the issues in the following order. First, I'm going to say something very briefly about the Ladin Marshall application with which my learned friend has just finished. Then I was going to take the issues on the substantive appeal for the main part in the order taken by my learned friend and in our skeleton argument. So starting with the iniquity exception, then dealing with the litigation privilege points, save for the issue raised at paragraph 5 of the grounds of appeal, which is about the Three Rivers number 5 point. My learned friend hasn't said anything about it. If anything needs to be said about it, my learned friend Mr. Pearce is going to have that pleasure, and he'll deal with that. At the same time, if anything needs to be said about the cross appeal, which also relates to the same point. One is
sorry, I'm being slow. What point is this?
Yes, the extension of one is the extension of Three Rivers number 5 client point to LIP, which the appellant contends. And one is we can't win before you, so we probably won't say anything at all about it. So Mr. Pearce is very disappointed, but there it is. You're bound by Three Rivers number 5. We just want to keep the point alive, as my lord knows. So I'm not going to be addressing those. If anything needs to be said about them, Mr. Pearce will deal with them. I'm then going to address the legal advice privilege, which is ground of appeal number 3, and that's the baton. Can I just start by saying something then briefly about the Ladin Marshall application? As my lords know, we have dealt with the first threshold issue, whether the new documents could reasonably and therefore should have been put before the judge, both in our original Ladin Marshall skeleton, which is in the further evidence bundle at volume 2, tab 9, paragraphs 15 to 16 and 20 to 25, and orally at the hearing before my lord, the Vice President, at the hearing in November. And in light of what my lord has said already in his, albeit provisional ruling, we will say nothing more about the first issue in relation to what are called the T18 documents. Those are the documents which were and could have been, were available and could have been put to the judge. On that basis, or ordinarily the T18 documents, if I can call them that, would not be admitted on this appeal. There were, however, as my lords will recall, a few documents, the T20 documents, which actually amount to just the Gerard email. There are some follow-on emails, but really we're talking about the Gerard email, which you just looked at, which we accept could only reasonably have been obtained after judgment, were only obtained after judgment, and could only have been so. And the fact that those documents, as I say, mainly the Gerard email, could only have been obtained at that point, raises two questions. First, whether the appellant could pass the second Ladin Marshall test in respect of those documents, namely whether they would probably have had an important influence on the result of the case before the judge, and therefore potentially on this appeal. And if so, second, a point raised by my Lord the Vice President, as to whether the admission of one or more of those few documents should in effect drag with them the admission of the T18 documents, even though they'd failed the first Laden-Marshall hurdle. Now, my Lord has left those points open so that they can be considered in the context of this appeal. We do say that even if you form the view that the Gerard email, which you've looked at and which we say doesn't amount to anything, even if you did form the view, though, that that was sufficiently important to admit that, we do say that that is not a good basis for dragging with it the T18. My Lord had in mind provide context. With respect, we don't accept that. The points made by reference to the Gerard email are essentially isolated documents, isolated points which don't require any reference to the other documents. So I'm not going to say more about that, and I'm going to pick up anything I need to say about the importance of either the Gerard email, though I've summarised my point already, or the other T20 documents as I go along in the context of the issues to which they're said to relate. And obviously, I won't pick them all up. We say what we say about relevance in the supplementary skeleton on the Laden-Marshall, which is in the Further Evidence Bundle, Volume 2, tab 11. I do just want to mention this, though. As your lordships will have seen, Mr. Allen, in light of what was said in the supplementary Further Evidence Bundle, has instructed or has required his team to do the whole exercise again of assessing the iniquity exception and indeed reassessing all of the privileged documents in the light of the further evidence. And he deals with that in Allen 17 in the Further Evidence Bundle, Volume 2 at tab 50. And he explains there that having done that exercise again, the conclusion is that there is just one sentence of 8 words, which had they been aware of that further evidence when they did their original disclosure exercise and provided subsequent tranches of disclosure, they would have considered fell within the iniquity exception. And that is on the basis that Mr. Allen accepts that the new material shows a strong prima facie case of hacking by Mr. Page and or his associates, and they consider that there is a strong prima facie case that the 8 words which were originally redacted were part of or in furtherance of that hacking, essentially in that they refer to Mr. Page and various Skype messages. And because they are relevant to the issues in respect of which disclosure has so far been given, that unredaction has occurred. But the headline point, I'll come back to the unredaction in due course and to what it does or does not show. But the headline point is, insofar as it's said that the further evidence shows that we need to do it all again, we've done it. My lords, the iniquity exception, and this is one of the 2, as it were, substantial issues on this appeal.
It's being looking at whether there are any documents that have a sufficient relationship with the iniquity of hacking. You say, we've done it all again.
No, they've been through the exercise again in light of the further evidence and have taken a view about the iniquity exception. If they'd seen something else, my lord, that worried them, I have no doubt that those behind me would have said so.
Perhaps this is the point at which to raise a more general point. You say the judge was right to go straight to what one might call stage 2 and determine the relationship question, and because he was right on that, he didn't need to decide the question as to the existence of iniquity. But your case in this application, your client's case, is that there were no iniquities inside the hacking firm. There were no relevant iniquities established to the relevant threshold.
Save in the one...
Save for the Mitchell. Save for the Mitchell, which was treated as confined to the 29th of October or thereabouts in terms of time. But that being so, the evidence of Mr. Allen that there are no documents that fall within the iniquity exception doesn't mean that any relationship test has been applied at all.
Well, it does mean, my lord, that he's looked, or his team have looked at the documents and formed the composite view relating to both stages. It's necessary.
But if the conclusion at stage 1 is no iniquity, that's determinative. They should never get to stage 2.
My lord, that assumes that the way it's been done, that they've simply asked themselves first, are we satisfied that there's, in the abstract, that there's not a sufficient case? And 2, then in respect of each document, my learned friend said, does it further? But that's not what is actually, we say, the exercise that's been done. What has been done is to go through to identify whether there is a strong prima facie case that there are documents in furtherance of or part of the iniquity. And that requires also an assessment of whether there is sufficient evidence that the iniquity itself exists. That's necessary part of that composite exercise.
It's not only necessary, but it's sufficient if the answer to that is no. What I'm putting to you is this. Suppose...
I see the point.
You see the point. If Mr. Allen is wrong, or his team were wrong in their assessment of the threshold being reached, isn't the exercise going to have to be done again?
If, having looked at all the evidence, as they have, and they formed the view that the threshold isn't reached, and for that reason alone, as it were, they never got to worry about anything else, and my lords decided that, in fact, there is sufficient evidence, even though those behind me have seen the documents and my lords haven't, but leaving that point aside, then I recognise that on that basis it is difficult to say that the evidence would not need to be reviewed again to consider the in furtherance of part, against the background of my lord's conclusion, contrary to what Enyo have concluded, that on the basis of the materials they have actually looked at, there is not a strong prima facie case of documents that are in furtherance of the iniquity, which, as I say, is a composite judgment going both to the question of whether there is sufficient material that they've seen to justify the iniquity, as well as bound up in it the furtherance of it.
Would it be right for us to proceed on the assumption that because it's your case in the application that the threshold wasn't reached as to the existence of iniquity? That was also the conclusion that was reached in the course of the exercise by the team conducting the review.
It would be certainly fair to conclude that they formed the view that, having looked at all the documents, there was not sufficient basis to conclude that there were documents in furtherance of...
Not my question. My question is, can we conclude that in conducting the review, they concluded that there was not a strong prima facie case of any iniquity?
My lord, that must be a necessary part of the way in which we advance the case. Yes. Yes.
It's a necessary part of the way we would advance the case, and therefore it's a fair inference that was the stance that was taken during the review.
That was the conclusion reached during the review, as opposed to the review having been done from a starting...
No, I don't suggest that was a preconception, but that was the conclusion of the review.
I wouldn't be standing here arguing that there wasn't a sufficiently strong prima facie case if those behind me had formed a different view.
And does it follow, therefore, that if it turns out that they were wrong about that in the view of the court, then the in furtherance of the relationship question is going to have to be revisited, because that was not addressed separately on the basis, if we thought there was iniquity, that all the documents will still be out on the basis that they don't.
I think that must necessarily be right.
Okay, thanks.
Does it also follow that they must have formed the view that specific references in documents to things like blindfolding, shackles, solitary confinement, and so on, counted as iniquity, but that documents which talked about Mr. Al-Sadeq's detention, but did not specifically refer to things like shackling and so forth, were irrelevant to any question of iniquity?
my lord, I would need to take instructions on that. I'm now being asked to check. I'm of course.
I mean, I ask because it seems to me that there is some evidence in heavily redacted documents which refer to the conditions not being human rights compliant, but one might have expected to see a fair bit of documentations which throw some light on the fact that Mr. Sadeq was detained. After all, Mr. Gerard, as I understand it, was going to the prison or military barracks or whatever it was to interview him and so forth, but we don't seem to have that.
My lord, that's not right. Everything that describes the conditions in which Mr. Sadeq was being kept has been disclosed. The minutes of all meetings with Mr. Sadeq have been disclosed. They have not been disclosed by reason of the iniquity exception. They have been disclosed on the basis that those behind me have taken the view that they do not represent confidential documents to the extent that the documents are descriptive of those conditions or those interviews. And therefore, all the materials my learned friend refers to about are because we have disclosed them on the basis they are descriptive. Now, Mr. Allen explains this.
Sorry, you're going a bit too fast for me.
Sorry, my lord.
The minutes of the discussions between Mr. Gerard or other Dechert partners or employees and Mr. Sadeq presumably would not have been confidential.
Exactly so. And therefore they...
Because he was there.
They've been disclosed exactly so, my lord. Similarly, we took the view...
Well, you were running that together with the question of what you call description of the process. That's a separate question.
Well,
it's true that the one might, in practice,
it was treated
cover both
in the same way for the same confidentiality reason. The view was taken, the documents were descriptive of things that he was privy to, as it were. The fact that he was, say, in shackles at one meeting. He was there and was privy to it. And therefore the view has been taken in Mr. Allen's witness statement, and he's explained this from the very outset. The view was taken that that material is not confidential and it has all been disclosed. So any description of the conditions in the documents that we have has been disclosed as primary material.
Suppose, for example, that Mr. Gerard, having had his meeting with Mr. Sadeq, goes and does what he says he's going to do, which is talk to the ruler about whether Mr. Sadeq has now said enough to be released or to have his conditions rendered more favourable. Now that conversation, if there's a record of it, is not going to talk about the conditions in which Mr. Sadeq is being held, partly because no doubt the ruler knows what they are, and partly because it's not very complimentary to the ruler to remind him that he's holding people in Article 3 non-compliant conditions. But nevertheless, a conversation about whether Mr. Sadeq has now done enough is a conversation about whether he should continue to be held in those conditions, even though the document may not refer to the conditions. So wouldn't that come within the iniquity
I am, of course,
exception?
going to come to this because I was going to try and set up a running order, and my lord has, with respect, jumped ahead to in furtherance of that question about whether such documents would be in furtherance.
Well, you come to that in your own time.
Going to address that. It's an
point
important
that I'm
point.
wondering about.
It's an important point, and I recognise that, and it's an example given by my learned friend, which I will, of course, come to. What I wanted to do, if I may, is to take the points in this order. I wanted to start with the question of whether the three iniquities are made out to the relevant standard. My learned friend said that the judge should have done that, what she said in writing, and we say that's an arid debate, but there it is. Whether arid or not, we're perfectly happy to engage that way. Slightly curiously, that was not then in fact the way it was done orally, but leave that aside. I am going to engage first of all with the question of, are the three iniquities made out to the relevant standard? I'm picking up my Lord's question about what the relevant standard is, although there's no live issue on this appeal in relation to it. Once I've done that, I'm then going to turn to the in furtherance test, as it were, in terms of the legal authority, or insofar as I need to. The test, or the descriptor of the test, is, I think, now common ground, part of or in furtherance of, but there's clearly still something between us, and that was the test that was applied by Mr. Allen. There is still something that's between us, I think, which I just need to touch upon as to what that means in the abstract, before I then go to the question of whether the examples that are given by my learned friends are examples, are places where one, she is right to say that there must be documents, and that if there are, those are in furtherance of or part of the. My lords, that's the approach. So the first question is, are the iniquities made out? And we make three preliminary points. The first, take lightly, we say something in the skeleton argument about the approach on an appeal to findings or fact or evaluations of the evidence. I quite accept that this is not, perhaps on this issue at least, the strongest case for particular deference, in that the judge dealt with it very briefly on this issue. But we do say, nonetheless, this is a review rather than a rehearing, and we do say that there is deference due to the evaluation of the judge on the evidence that was before him, which is subject to the FE point, no different to the material before you. The second preliminary point is that one of the few matters not appealed is the judge's conclusion that the requisite standard to which the iniquity exception needs to be established, in other words, both the fact of the iniquity itself and the existence of documents in further of that iniquity, or part of it, is a strong prima facie case, if not a very strong prima facie case, that being the test put forward by Lord Justice Longmore. We say that's ratio, I'll come to that in a moment, in the Q8 Airways case.
Does that mean strong prima facie case? Do the words, if not a very strong prima facie case, add anything? Or are they to be meant to mean, in reality, a very strong prima facie case?
My lord, I understand.
If not is always rather ambiguous.
Maybe, my lord. The way in which we would invite my lord to read it is that the test is a very strong prima facie case, but the difference between the two, for reasons I'll come to, may not be significant. This is a sliding scale. It's difficult to gloss this too much. We can, if I added the word very, very, keep on going. So, my lord, it's not, I think the point is one of emphasis as opposed to some strictly different legal analysis. But we do say that Lord Justice Longmore, with whom Lord Justice Ward agreed, held and deliberately decided to set out as principles the point about the burden of proof at the end of his judgment, and as I'll come to, that has been treated as the approach to be applied in all the leading textbooks. Obviously, with this qualification, it's one of the issues in the action, and I'm going to come in a moment to my lord's point about that. As I say, this issue now does not arise. It didn't arise on the appeal, and my learned friend has very fairly accepted she's not going to challenge it. So this is really for my lord's benefit, and if you'll therefore forgive me not taking too long over it, but I will just say a few things about the cases that are in the bundles. There are obviously very few cases specifically dealing with this, but some of the key ones are there for other reasons. O'Rourke is the first in time. I'm not going to take you to it. You've looked at it. But for what it's worth, Lord Justice Longmore obviously looked at O'Rourke in Q8, so he was well aware of it. It is, we say, as my Lord Justice Mayles said, it is authority in this regard only for the proposition that mere allegations of iniquity, as they were in that case, are not enough. That is the extent of it as authority on this point. It is right, of course, that the members of the House of Lords did explore, obiter, what more might be required in another case, but they all answered that with varying formulations, as my lords have seen, both in terms of formulation and in terms of the sort of evidence they had in mind. Viscount Finlay at page 79 does appear to have considered the standard might vary depending upon the circumstances of the case, and it may be that that is where the notion first takes up, that depending upon the type of case, which one sees in Q8, the test may, the bar may be raised. Derby versus Weldon, which we haven't, I think, really looked at. Can I just show you that very briefly, because it's quite instructive on this point. It's in the authorities bundle at tab 13. At page 253. My lord, the standard of proof was considered in some detail in this case. It was the issue, including by reference to the judgments in O'Rourke, taking each of them separately and setting out what they say, and for good measure throwing in what Lord Justice Scrutton had said in the Court of Appeal in O'Rourke. So you'll find all of that at 265 of the internal pagination. I'm not going to invite you now to read it all, but it is, it sets out conveniently all in one place for you, the paragraphs from O'Rourke. And then, so you have it at page 269. You see reference there to the British gas and oil case. And you see what Lord Denning said at C. To do away with the privilege at the discovery stage, there must be strong evidence of fraud, such that the court can say this is such an obvious fraud that he should not be allowed to shelter behind the cloak of privilege. So you see already coming in the language of strong, my lord. And then Lord Justice Donaldson said he respectfully agreed and find it unnecessary to express any view on how strong premeditation in case of fraud is necessary to defeat a claim for disclosure based upon legal professional privilege, but something exceptional is called for. And then at the bottom of page 269, Weinlock rejects the suggestion that the test is on the balance of probabilities, and my learned friend said it's not that, and we agree it's not that, because balance of probabilities means making a final, actual finding of fact. It's a final conclusion, and that is obviously not in a preliminary, an interlocutory what is being done.
Sorry, where I'm just trying to find the passage where he addresses this. 269, did you say?
At the bottom of 269, and going over the page.
Oh, I'm so sorry. Yes, of course, right, just over the top of the pages. Yep.
So even in the course of page 269, it seems to move from strong evidence with Lord Denning to very strong evidence indeed in Lord Justice Waller.
My lord, yes. And then at 270, A to E is where Justice Weinlock seeks to make sense of the various passages he's looked at. And ultimately, as you see at E, he concludes there is a continuous spectrum, and it's impossible to, as it were, calibrate or express in any simple formula the strength of the case the plaintiffs must show in each of these categories. And each of these categories is injunctions and the other things that are dealt with at an interlocutory basis. In order to disclose documents for which legal profession privilege is claimed lies at the extreme end of the spectrum. Such an order will only be made in very exceptional circumstances, but it is, I think, too restrictive to say the plaintiff's case must always be founded on admission or supported by affidavit evidence, or that the court must carry out the preliminary exercise of deciding on the material before it, that the plaintiff's case will probably succeed. A task which may well represent an insurmountable difficulties in a case where fraud is alleged and the court has no more than evidence. So that's what he says. For what it's worth,
And there's rather a tension there, isn't it, between on the one hand saying you need strong evidence or very strong evidence, but on the other hand, not such as even to enable you to say that on the material I've got, even though recognising there may be more at trial, I think it will probably succeed.
well, my lord, we do say that the strong prima facie test does require you to form the view on the basis of the material before you, recognising it's an interlocutory stage, that the allegation is more likely to succeed.
I'm sorry. That's not what Mr. Justice Weinberg seems to be saying at the top of the page, and I thought you accepted that was right.
We say that the balance of probabilities test at the top of the page it is actually referring to a conclusion. The test, the facts are made good.
But it's not, because it says will probably succeed, so it's plainly not a final finding.
It's helpful, possibly, to look at what he says in the next paragraph, and referring to two other passages from O'Rourke, which seems to be more to do with how much detail is given, which may seem odd, but actually isn't, given the nature of the exercise. It's whether something is done with great particularity, which would suggest that it's plausible and to be taken seriously, rather than that you can form a view as to how likely it is to be true.
Well, my lord, we do say that is in real tension with the suggestion that it is at the extreme end of the spectrum compared to, for example, injunctions and such like. There's a spectrum, and Mr. Justice Weinberg puts it at the far end. The test that my lord is describing, and I understand why he says it based upon the passage, it would actually be at the lower end of the spectrum, even on an injunction type application.
Well, it's difficult to generalise, isn't it? You have to look at how the allegations are put forward in any particular case. There may be a limit to the extent. It's very helpful to see how Mr. Justice Weinlot dealt with this. He obviously dealt with it with some care, but at the end, this isn't binding on us, and the law, there's a lot of further authority.
Probably a mistake on the advocate's part to have tried to assist on this, on a point that's not an issue, but I understood you wanted some assistance.
No, I'm not saying this is helpful, but I'm saying we probably got as much out of it as we can.
I would accept that, my lord. But I was just going to give you the reference, Barclays and Eustace. I'm not going to take you to it. It's tab 15, page 295. But the Court of Appeal in that case referred to the test as being a strong prima facie case at 303G, or let me correct that. It applied the strong prima facie case test.
It described the evidence.
It described the evidence as established. That's a fair
Well,
assessment.
it did a bit more than that, didn't it, G? It said the next question is whether there is also a strong prima facie case. So it was expressing
to
that.
assume that is the relevant question, my lord. Yes. Then there's Queen against Gibbon, which my lords have clearly looked at. There are passages which would invite you. It's a tab 23, page 457. But the passages my lords probably most interested in this is 49 to 50. Yes, the relevant paragraphs are at 470. I said relevant. There's a sort of study of the whole subject matter that precedes it. Again, I wasn't going to go through that. I'm just trying to alert you to where it is. You've clearly already seen it.
Yeah.
And the issue, of course, in this case, though, was a slightly different one. The issue was it the criminal standard that applied? And the court held it wasn't. And that being the case, they had no difficulty with the judge's conclusion, which was based upon a strong prima facie case, and they said that was unimpeachable. They do, in paragraph 50, prefer to keep with prima facie, but they also say that the references in cases to probable and in the cases to strong prima facie case, we consider that these observations rightly emphasise the need for the judge to be clear in his view that a prima facie case of fraudulent purpose exists. If my lords find that more helpful, then so be it. It's really just another way of trying to emphasise.
It reflects your point that the use of the word strong or very strong is a word of emphasis rather than one which affects the test itself.
Lord, yes. And then the next and final piece in this is the curate case, at least as far as these authorities are concerned, and that's at tab 24, starting at page 474. And it's the ultimate conclusion that we rely upon in paragraph 42, page 490. As I say, we do say that the Court of Appeal has then sought to state the proposition once and for all at paragraph 42. And if you go back to how the Court got there, it reviewed the authorities, in particular at page 485, at paragraph 28, the Hallinan case, and then which was that was not called an appeal case, and then at 29, you'll see that was a case. Justice Thornwell starts to draw out the point that it may be different, the test, depending upon whether it's an issue in the case or not. Then in paragraph 35, there's a reference to the Chandler case, to which my Lord Justice Popplewell referred, and that's the decision of Justice Hoffman, where he does refer to discretion. I'll come back to that point, if I may, in just a moment. And then it's paragraphs 36 and 37, which are particularly important, where he identifies the reason why one needs to be cautious. And it's particularly the first of those in paragraph 36, and then what he says in 37 that we rely upon. My Lord indicated that he wasn't convinced by the distinction between a case where it's the iniquity is one of the very issues in the case. We, with respect, say it is right that there should be more caution in such a case, essentially for two reasons. The first is that there is a necessary element of judgment about what is a very issue in the case, though I accept that is true in other contexts. That is the way in which the court has to approach it. But also, and perhaps more importantly, because the ramifications of a wrong interlocutory call or judgment on the iniquity exception are particularly acute in such a case. My learned friend suggested that if the defendant, in fact, wins the case, then no harm is done, as it were. That's not really the way privilege works. Their privilege will have been abrogated on the basis that it shouldn't have been. Moreover, it's a false assumption. It's perfectly possible, for example, that no iniquity is made out, but there's negligence, and the disclosed material, which should have remained privileged, establishes a different case for which it should never have been available. My Lord, we do say that is a problem, because once the material's out there, it's out there. There's no closing the box. So we do say, my Lord, that those are reasons why one has to be extremely careful. Privilege that is on the face of it there, subject to the iniquity exception. Privilege is obviously a fundamental right which one needs to pause long and hard, we would say, before concluding that it should be torn away on an interlocutory basis. The key point remains, though, that whether the test is very or strong, it's the real caution in this particular area is, we say, required, so we do say that is the correct approach. We do say it is captured by the very strong test, very strong prima facie test, and we do say that that is the ratio, the decision in that case, and it's binding. For what it's worth, my lords, that is the approach that is then adopted in all the leading textbooks in Thankey, Hollander, Passmore, Zuckerman, Malik. We are in the process, if my lords want to look at the treatment on this point in those textbooks, there's quite a long treatment. They track the history of the development of the burden of proof through the cases, and if my lords are going to write, as it were, the definitive work on this, then we're very happy to make those available to my lords.
I think that would be helpful. It's not a promise that any of us will write the definitive work. In for a penny. Now we've wrote this
You may have a
box,
better chance with the material than without. Finally, my lord will recall that in the Ablyazov case, your conclusion again was that very strong prima facie test was met. Again, I'm not saying that my lord said that that was the test. It's just that it was.
Well, I think I did say that was the test, but that wasn't an issue, and it wasn't very difficult to conclude that it was met in that case.
My lord also, though, referred at paragraph 90, paragraph 109, where it's fair to say you also then referred to a strong prima facie case, having held that it passed a very strong prima facie test. My lord then did say that, referred to the fact that the standard of proof in this context is a high one, and we say that that was right. My lord then went on to say that even if it was met, there is a discretion in deciding whether to go behind the privilege. Just pausing, plainly there is no discretion to go behind the privilege if the standard is not met. I think everybody has that. It may be that my lord's approach reflected that of Ms. Justice Hoffman in Chandler. The difficulty with it, my lord, is this. What is a solicitor trying to conduct a disclosure exercise to do with a discretionary element that involves weighing up those competing interests? The test that exists in this area needs to be one that a solicitor can comfortably apply on the ground. These are real problems for real solicitors trying to do their best. And to introduce, as it were, a backstop of a discretion causes a real problem. They are then being asked to weigh up some unknown and variable considerations in order to form a view about what to do in any case. And we say that is, my lord, at a practical level, problematic. I understand why my lord went there, but I just alert my lord to what we see is one practical problem with that being the right approach.
I understand that, certainly in terms of the Chandler and Church approaches to balance of irremediable prejudice. I think as with all disclosure things, there's a discretion at the end of it, and the sort of discretionary factors with which I was particularly concerned weren't so much balance of irremediable prejudice, but expense, utility, and questions of that sort, which will also always arise, and solicitors have to cope with. I mean, solicitors are always entitled to say, there may be 5 documents in this vast warehouse, but I shouldn't have to search through it in order to find them.
And it may be that my lord would say that the solicitors do not need to do a balancing exercise of the sort that might be contemplated. Theirs is to apply the test, as it were, and it's only if it comes to an application that someone might say something different. But I just note the problem, my lord. We do say, though, that there are 2 additional considerations in this case which should urge particular caution. First, and unusually, though not without precedent, the privilege is that of parties, Dechert's former clients, who are not before the court and are therefore not being heard. My learned friend would no doubt say that they could have been before the court if they'd chosen to, but we say there's an air of unreality about that. The idea that emanations of a foreign state, RAC, should volunteer to come before a court for this purpose in a case in which they are not a party is fraught with difficulty.
Well, a party usually relies on its lawyers in the disclosure exercise to protect its privilege. Subject to Miss Oppenheimer's point, which may not be a good one, that here you've got two stages of lawyers rather than one. One normally expects privilege questions to be argued on the basis of the points that the lawyers regard as the appropriate points to take on behalf of their clients. I'm not sure that the fact that RAC hasn't participated is important to say.
My Lord, the second point is that what is being asked by my learned friends or by the appellant is that you take away a privilege that otherwise appears to exist, subject to the other points, on the basis of whatever the test is, finding that the iniquities exist. And those are obviously serious matters, though, the relevant iniquities. And although, as I'll come to, it is not said that my clients had any involvement, it is said, effectively, that the RAC authorities did these things. And we say that does raise, for the equation, as it were, considerations of international comity. And it's akin, in a sense, to the situation on a jurisdiction challenge, where it is said that the foreign jurisdiction, even if it's otherwise the natural forum, is not a place where justice can be done, and the court requires cogent evidence and submit such submission to anxious scrutiny before acceding to it. That's the Supreme Court in the Vedanta Resources case, as I'm sure my lords know. So we do say that if ever there was a case to be cautious about making any findings to the relevant standard, it is, we say, this one. My lords, the third preliminary point which I wanted to make,
Sorry, just before you leave that, it's been very helpful. I don't want to take too much more of your time, but Mr. Justice Weinlock said there was a spectrum, and he said that for all these different things, no one had, such as interlocutory injunctions, no one had formulated a test, but he's not quite right about that. There is quite a well-recognised test in the context of jurisdiction. What do you say?
We don't say
prima facie case is, or strong prima facie case is, on that spectrum in terms of probability?
We say it is it is not, we say, the same as the test at the jurisdiction. The good arguable. Okay. Let me start with what it's not. It's not that it's not strikeable outable, if you follow what I mean.
Not serious issue to be tried.
It's not a serious
not real
issue.
prospect of
Not
success.
real prospect of success, as was at one point suggested. O'Rourke says it's not that.
Yes.
We say that it is a conclusion that, based upon the materials before the court forms the view that it is likely that the allegation will be made out.
That just substitutes one ambiguity for another, because likely is a well-known ambiguous term. Do you mean more probable than not?
And strong means much more likely, and very strong means very much more likely. I'm wary of keeping on glossing this.
No, but you do have to pin your colours to some mast, because we're going on to ask, is the test fulfilled on the facts of this case?
Said what I say the test is.
And you've got to have a case as to what the test means.
Yes, and the test
It means it's more probable than not on the
based
material
upon the
before the court.
materials currently before the court. That's a prima facie case.
Well,
And strong prima facie case means much more probable than not, or just clearly more probable than not as a matter of emphasis So that one needs some
The
clarity,
latter.
clarity in the evidence.
The latter.
Do the materials before the court include the materials which are not before the court, but which might reasonably have been expected to be? In other words, things like absence of denial.
If an absence of denial, it depends is the answer. The abstract answer is that the court can obviously have regard to evidence that it might have expected to see if it's not there. That must be.
That's material would be more accurate way of putting it,
Material.
evidence, because pleading isn't evidence, though of course it will have a statement of
Well, it's
truth.
got the statement of truth, so I accept that. But if my lord was specifically on the absence of denials, I don't accept that insofar as the point here is that there are things that we've not admitted because we don't know, that is in the category of things which should concern my lord. We don't know, and therefore we've perfectly properly not admitted it, rather than denied it or admitted it. I don't accept if the suggestion is that because it's a non-admission rather than a denial, that somehow suggests there's more to it. And I'll come to particular instances in a moment, actually, of where there are non-admissions, but we actually still advance a positive case as to what our understanding was, which is rather overlooked on the other side. So we do say one needs to be very cautious, my lord. Yes. The third preliminary point I wanted to make, which is of some importance given the way in which the appeal was presented by the appellant, which I therefore want to spend a little bit of time, is this. The court will need, we say, to keep firmly in mind both what the relevant alleged iniquities which are the subject to the application are, and equally what they are not. Can I just ask my lords to go to Mr. Siatlu's sixth statement at the supplementary bundle, volume 1, tab 2, page 32. Paragraph 55. You will see that Mr. Siatlu there lists out the various categories of iniquity which are alleged in the case and which Mr. Allen accepts were assumed to be iniquitous for purposes of the disclosure exercise. And the ones relied upon are point 1 and point 2, which are in fact combined into the first iniquity, though I'll say in a moment that in fact comprises 5 different points. Then the second is the torture and inhumane treatment at point 3, and then the third is denial of legal representation at point 4, and you can see all of that replicated in the order, my lords, which is sought. Just to remind you, that is in the core bundle at page 14. Just for your note, A, paragraph 3A, that embraces 55.1, 55.2, and there are, as I say, in fact, 5 different points there. There's the detention and rendition, detention in Dubai and his rendition to Ras Al Khaimah, and there is the subsequent detention in the following 4 locations. So really 5 different points, all of which, although it's not put this way in the order, all of which are said to be unlawful. Then there is then the conditions in which Mr. Sadeq was detained in each of the 4 locations. Again, that's essentially 4 different places that one needs to consider. And then the third point is the access to legal representation.
Sorry, I mean, I'm not being picky. I just want to understand. I can see why you break down A into detention in Dubai, rendition to RAK, and subsequent detention. But the location where he's detained is not really material.
Well, it is, my lord.
Well, it may be material for point B because the conditions might be different in different places.
It could also be material for point A. Although my learned friends have actually spent no time on it, either in writing or orally, it is said that the detention on each of these places is unlawful for some reason as yet to be identified. But let me test it most acutely, my lord. Condition in RAC Central Prison follows the imprisonment of Mr. Sadeq, having been convicted by a Ras Al Khaimah court of various frauds. It is difficult, just taking an example, to see on what sensible basis it could be said that detention pursuant to an order of a court following his conviction could be said to be unlawful. Different places may give rise to different considerations, is the point I'm making.
Yes, I see. Very well. No, that's...
My lords, then what is equally important is to look at, back at paragraph 55 of Seattle 6, what is not relied upon. Those are the iniquities which they did not seek to rely upon to make good the iniquity challenge. And most striking of them is 55.6, extracting false confessions, which is one of the allegations in the case. And a key distinction between the matters on which they did seek to rely and the others on which they didn't is that the former, the ones they did seek to rely upon, were all things alleged to have been done directly by people other than my client's Dechert and the relevant individuals separately represented. They chose, the appellant, he chose, to mount his jurisdiction...
Sorry, I'm being slow at this, folks. It's that time of the afternoon.
Yes.
55.6, yes, would be at least partly done by Decherts on the allegations made. But that's not evidently true about 55.5, 55.7 or 55.8.
No, the allegation is, my lord, that threats to the claimant and his family were made personally by
yes.
Dechert, and that they...
And likewise 55.7
participated unlawfully in an unlawful search
I
of
see.
property.
Okay.
And in 55.8, that Dechert themselves have been involved in the obstruction of these proceedings.
Very well. I hadn't picked that up. Thank you.
What's important is that the appellant chose to mount its privilege challenge on a basis which not only expressly abjured any attempt to show that the respondents were culpable for any iniquity, which is the way in which my learned friend put it yesterday, but also they abjured any attempt to show that we were aware of any iniquity or involved in any iniquity. Can I just show you that in the same statement, going back to paragraph 50? You see, it's important to note that this application is not concerned with the defendant's culpability or level of knowledge or involvement in the categories of iniquity relied upon. And then carries on. That is a material for this application, which is not concerned with the defendant's conduct. And the same point was then made, I'll give you the reference to it, in Mr. Siatlou's reply evidence in his 9th witness statement, paragraph 4, which is at page 182 of the bundle. And it was also said in the skeleton argument below, which is in the supplementary bundle at tab 36, page 418, at paragraph 6.3. So they were not concerned to show that we were involved at all, that it was to do with our conduct. And that necessarily ruled out iniquities in which we were said to be the primary actor. On this appeal, however, a recurring theme of the way in which the application is put is that the purpose of the 3 iniquities relied upon was to obtain evidence from Mr. Sadeq, which he would not have provided but for those iniquities. And indeed, that seems to have become something of a bedrock of the way in which the case is now put. One sees that most clearly, for example, in the ground of appeal, in the core bundle at paragraph 1.7.
So sorry, where are we going to?
I was just showing you in the grounds of appeal, reminding you that this is one of the points they take in the grounds of appeal at 1.7. It's the failure to stand back and see that the purpose was at page 18. I'm so sorry. Tab 2, page 18. Just remind you of that. And similarly, my lord, if you go to tab 3 to their skeleton argument for the appeal, paragraph 17.3 at page 34, so-called overarching error.
So I'm still behind which paragraph?
17.3 of the skeleton argument on page 34, my lord.
Thank you.
And then similarly, paragraph 50 of the skeleton argument, again the big picture standing back, a point on page 53 of that document. And my learned friend made the same point a number of times orally. But my lords, we say there are three problems with this focus on the supposed purpose of the alleged iniquities, which you have relied upon. First, it effectively amounts to reliance on an entirely new and distinct form of iniquity, the gathering of evidence by allegedly unlawful means. And one can see that most obviously from the fact that in the skeleton argument, I'll just give you the reference at paragraph 49.2 on page 52, it is now said that this is really a case on all fours with Dubai Aluminium, an unlawful gathering evidence case. What is said is it's materially indistinguishable, and therefore an order in the same terms as Dubai Aluminium should be made, which is in fact the order that is sought. But that is not the iniquity that is in fact relied upon. It is a rewriting of the iniquities relied upon. Second and relatedly, recasting the iniquities by reference to their alleged purpose is fundamentally inconsistent with the entire factual premise of the appellant's challenge to privilege, which is that it is not concerned with Dechert's conduct at all. And it is inconsistent because it is Dechert that did the evidence gathering, which is now said to have been unlawful. So far from the challenge not being concerned at all with Dechert's involvement in the alleged iniquities, on this new way of putting it, Dechert's involvement becomes absolutely central to all the iniquities. Their raison d'etre is said to be so that Dechert can obtain information. And you can see that very clearly, my lords, if you look at the end of paragraph 50, which I think we were at, of the skeleton argument on page 53 of that bundle. The instructions given by Dechert's clients to Mr. Gerard to interview Mr. Sadeq there, and any reports given by Mr. Gerard to his clients following those interviews, self-evidently form part of that iniquity. They represent its very purpose. My lord, that is to recast entirely the iniquity, and it is only by entirely recasting it that one is able to say, as my learned friend does, that it is part of the iniquity, the gathering of evidence. We say, in fact, that self-evidently any such instructions or reports are not part of or in furtherance of the conditions in which Mr. Sadeq is alleged to have been detained. A discussion about going to obtain evidence is not part of or in furtherance of those conditions, or indeed any of the other iniquities upon which the application is made. And the third and final, and perhaps most fundamental difficulty of all, is that there is simply no evidence before you to establish, to whatever the relevant standard is, that the purpose of the three alleged iniquities is as asserted by the appellant. Now, the purpose of the arrest of Mr. Sadeq was, we say, not to obtain information from him, but because he was suspected of fraud for which he was later convicted. But even if a reason was to seek information from him, it does not begin to follow that that was the purpose of the three alleged iniquities. Mr. Seattle's 6 does not refer to that alleged purpose, still less give him any evidence about it. Seattle 9, likewise.
Even if Mr. Al-Sadeq is guilty of the frauds of which he's been convicted, it would still be iniquitous, wouldn't it, to kidnap him and make him subject to extraordinary rendition and then hold him in inhumane conditions.
With respect, my lord, a completely different point. We have never suggested that being guilty of an offence is a justification for breaching someone's human rights. That is not our case, and never has been.
So all I was really exploring was that the iniquities on which the appellants rely don't depend on whether he was being asked to give false confessions or was in fact guilty of the frauds of which he was accused.
But they do, the way they put it orally and in writing, as I've shown you, now want to link it all to the giving of evidence, to the extraction of evidence, the interview process. And we say for that, there is no evidence at all, which is, I think, my lord, with respect, a different point to the one my lord was making. And if, when you see those references in the skeleton argument to the purpose, you will note that, in fact, there are no references to evidence given alongside them. The one exception to that is in the skeleton argument of paragraph 31.2 of the Roman 3, where some extracts from Mr. Sadeq's own letters are referred to, which we say simply don't support the point which is being made, namely the purpose of the conditions in which Mr. Sadeq was detained, whatever they were, was to obtain evidence which would otherwise not have been obtained. And equally, none of the material in the note that my learned friend has been allowed to put in at subparagraph 3 goes to that point either. It deals with a different point, essentially about whether, having been detained and detained in Ras Al Khaimah, he was questioned. There's no debate that he was questioned about things after that. That is not the same, though, or even close to being the same, as to say that if the conditions were as alleged, that was for the purpose for which they are now said to have been imposed.
Well, if you keep someone in inhumane and degrading conditions of imprisonment of the type alleged by Mr. Al-Sadeq, and if he complains that that is having the effect that one might think it would normally have in terms of encouraging to give false confessions or something of that nature, can one not infer that that was the purpose?
My lord, we don't say that that is a fair inference on the facts of this case at all. Taking the points in turn, the point about the unlawful detention in alleged unlawful detention in Dubai, assume for the moment that the relevant, make no assumption. What is said is that he was detained in Dubai without the relevant request having been made as required by a 1973 law between the various emirates. We say that if that is so, the much more likely inference is that in practice by 2014, that is simply not the way in which the emirates worked in these matters between them. There was a cooperation. That is the much more natural inference than that, as is said, Ras Al Khaimah authorities rode over the border into the other emirate and risked a diplomatic row by extracting someone without making the request, which was perfectly straightforward to make. We say there is no basis, supposing if there is an unlawfulness in the sense of the relevant request was not made, that was for some purpose to acquire, as it were, information improperly. And equally, we say, for example, that if the conditions were as they are said to be, we don't say, except that it's an inescapable inference, that was for the purpose alleged. It may be, and I don't say this in any way trivializing the seriousness, the great seriousness of the allegations that are made by Mr. Sadeq for one moment, but it may on this hypothesis be that Ras Al Khaimah is just not a place in which you want to find yourself arrested for having stolen from the state. Now, it may just be that those are the conditions in prisons in Ras Al Khaimah. And indeed, the evidence that they rely upon on the other side...
Well, not prisons generally. We're talking...
No.
We're particularly focusing on Al-Bahrain.
We may leave both places. GCHQ, which is the main police station, Al-Barat, the prison villa, so-called, which was supposed to be a sort of bonus, didn't work out that way, and then the main prison. In a sense, the human rights reports that are relied upon on this point work against my learned friend, because they suggest that this is the nature of being, or can be, in some situations, the nature of being imprisoned. And there's nothing in the human rights reports to suggest that that was for the purpose of extraction of information. These are people who were accused by the state of doing things, and they were imprisoned. And they said that the conditions were appalling. But the inference that is drawn and has become a sort of central theme of the way in which it's put is not the one we say that is justified on the evidence. Indeed, there is no evidence. And to conclude that there is a strong prima facie case, or whatever my lords decide is the relevant test normally, but in this case, it is a strong prima facie case, we say there's just no basis for it. The only other point I just make is that right from the outset of his detention, starting on the 5th of September, Mr. Sadeq wrote to the ruler to say that he wanted to cooperate. Before all of these things, the conditions and everything had happened. And from the very first meeting at GCHQ with Mr. Gerard, he said he wished to cooperate. Again, given all of that, what is the basis for the presumption that they ask you to make? That this was all for that purpose of extracting information.
I see the time. If that's a natural break, I think we should probably break here.
My lord, that is a very natural break, and I will stop there.
Very well. 10:30 tomorrow.